Before we call the meeting to order, we will go ahead and hear instruction on how the public may access Spanish interpretation.
Sorry. I have no idea why it's doing that.
Hi, we're unable to hear the Spanish instructions. Are you able to hear us on our end, Leonardo? Okay, I'm not sure if he is able to hear us on our end, but instructions are listed on the front page of the agenda.
Give us just a second, please. All right, hopefully everyone who needs interpretation is able to access that. And with that, we will go ahead and call this meeting to order. Could everyone stand for the Pledge of Allegiance? Thank you, everyone. And with that, we will go ahead and go to roll call.
Yes, I will be taking roll. Chair Viorchek,
Here.
Vice Chair Luxinger,
Here.
Commissioner Feiger,
Here.
Commissioner Imhoff,
Here.
Commissioner Williams,
Here.
all present.
Thank you. With that, we will go ahead and move on to public communications. So this is the public's opportunity to speak on any subject which is not on today's agenda. Comments will be limited to 3 minutes. Do we have anyone in the audience like to speak? Seeing none, let's move to Zoom.
Yeah, we'll go ahead and open up our Zoom platform for anyone who would like to provide general public comment. And there are no hands raised, Chair.
Thank you so much. And moving on to our consent agenda. And once again, we will take comment on the agenda. So this is our last month's agenda. Do we have anybody in the audience? Nope. Let's go to Zoom.
No hands raised over Zoom.
All right, we'll bring it back to the Planning Commission for discussion and a motion.
I move to approve the consent agenda.
Second. Natalia and Stephen, are you seeing the option to vote?
No, I'm not seeing it.
Are you on the item number 1? I can manually select the vote for you as well if you would
Yeah,
like to
that's-
verbally say your vote.
Interesting, it never popped up. Yeah, let's just go ahead and do it.
All right, Natalia, do you, how do you vote?
Aye.
And Commissioner Imhoff? Okay, that motion carries.
All right, thank you. With that, we will get right into the meat of it and move on to our unfinished business, which is our vacation home rental application denial appeal at 759 Lakeview Avenue. Since we already went through sort of the quasi-judicial process of this at our last meeting, we will not do that again. And Dan, I would love your advice.
Yes, so before we get started, I want to just make a statement for the record and a request to the commissioners, then I'll give you some details on how we'll proceed. So first, I just want to note for the commissioners, the Planning Commission's decision-making authority with respect to VHR permit denial appeals is limited to applying the rules that City Council has set forth in the VHR ordinance. And also, I'd like to ask all the commissioners at this time to disclose any ex parte communications you've had with any third party regarding the subject matter of this appeal. And if you have anything to disclose, please just provide a brief description of the conversation and the parties that were included in it.
And start. I haven't had any. All right.
I haven't had any.
Neither do I.
None to report.
I just spoke to the city manager and the city, one of the commissioner or council members about it, and they really didn't have much input on their end.
Okay, so we continued this from the last meeting. Where we stand now is the commissioners have requested additional information to help you with your deliberations. So we provided a memorandum that describes this. Mr. Hitchcock is going to go through those, the information briefly, and then we'll turn to public comment and then your deliberations.
Is our applicant going to have the opportunity to speak at all? Or is this just between staff and public comment and then planning commission?
I don't believe that there's an opportunity for staff or the applicant to speak at this point. We're going to provide the information. He's already had the opportunity to speak, and then we'll move on to deliberations after the public comment period.
Appreciate it. Thank you. All right, Mr. Hitchcock.
Thank you, Chair, and members of the Planning Commission. For the record, John Hitchcock. As Mr. Barzell mentioned, this is a continuation from last month's meeting of denial of a VHR application at 759 Lakeview Avenue. Mr. Barzell did provide you with a memo. It's on page 45 of your packet. I'm just going to summarize it quickly. The city offers the following responses to your clarifying questions. Does the unconstitutionality of Measure T be considered in deciding a VHR permit denial appeal? The city's response is the court ruling is not relevant. The application was considered under a new set of ordinances, and thus Measure T should not be used in your deliberations. Your second question, despite the court's finding Measure T unconstitutional, should the Planning Commission still consider the upheld citations for the appeal? The city's response is yes. The judgment on Measure T has no bearing on the upheld citations issued during the implementation of Measure T. The court granted injunctive relief looking forward, thus previous citations are valid and should be considered in the appeal deliberations. Your third question is weight given to the different types of violation. No, the code does not attribute different weights to different types of violation, and there is no legislative history that indicates the council intended to attribute weight to different types of violations. The record points to the council expressing the desire to increase enforcement and prosecuting violations of the ordinance to reduce impacts to affected neighborhoods. Question number 4, did the council intend the ban to be permanent for violating the code? While no legislative history could be found on this issue, it is irrelevant to the appeal. The language of the ordinance is clear on this issue, and there was no discussion by city council or concerns expressed that violations ultimately would result in a permanent ban. Your fifth question regarding receiving multiple citations. The legislative history indicates that the city council did discuss the timing of citation, but excluded the language that would have otherwise required 24 hours between each citation for the purposes of determining the 3 citation threshold. And that includes my summation of Mr. Barzell's memo. Thank you.
Thank you for that. And do we have the opportunity to ask any clarifying questions regarding the kind of, I guess, the answers to these questions, or is it just straight back to us?
Yes, you can ask clarifying questions if you need to.
I appreciate it. Okay, do we have any clarifying questions for Mr. Hitchcock? Mr. Imhoff and, okay.
Mr. Hitchcock, I disagree with some of those findings. However, at the advice of the city council, I can have to refrain from some of my comments. But do you not think that since Measure T was found to be unconstitutional, I have information regarding that effect, that the actual ordinance that was construed or constructed because of Measure T, you don't find that to have call into question? You don't find to be that ordinance to be called into question?
Mr. Hitchcock, I can
Okay.
respond to that. First of all, Commissioner Emhoff, you're welcome to put any statements you need to on the record. I'm not recommending you don't make any statements or pose any questions, so feel free to do so if you'd like. Regarding the constitutionality issue, we did provide a response in the memo that goes into that. The gist is that the judgment in the Measure T case was forward-looking. It doesn't impact citations issued during Measure T. Then as to the second part of your question, when Measure T was ruled unconstitutional, it did not place any limitation on the city's ability to adopt a new ordinance that would regulate VHRs in the city. The only thing that would be unconstitutional there would be the one limitation placed on that resulted in Measure T being struck down. That is not included in the existing VHR ordinance. And there's no constitutional issue with this at this time.
Then, since I'm free to make a statement, we will talk about the constitutional rights. Since I'm free to make a statement, I will.
Actually,
I'm not.
let me pause you for a second. The advice I previously gave was that written statements are not appropriate for an appeal matter because we're only supposed to be considering evidence heard during the hearing. So you're free to make a statement. I would recommend not using a pre-written statement.
This was not pre-written. This was coming out of a judicial review that is just merely typed from my computer onto this paper. And it's going to be difficult for me to judge this matter based upon the information that I have received due to the fact of the potential violation of this man's constitutional rights as it pertains to the city ordinance, and this is very important to that area.
My recommendation would be that if it's information that you received outside of the evidence presented and the information presented in this case, that you should not rely on it in your decision-making, and you shouldn't read it at this time.
That's going to be impossible.
I have a quick question. Since I understand where Mr. Imhoff is coming from, but I'm guessing that what you're trying to say is not a direct question about the specific items. So my thought is, would this be something that would be possible to be stated during the public comment portion of this item?
By Commissioner Imhoff?
Yes.
I would be most happy to do so.
If it's a general thought on the VHR process and our general framework for it, I would suggest commissioner reports would be a more appropriate time to raise this. I don't think it should be included in connection with this item because, again, this is limited to the evidence that's been presented and the information that's been provided. So I don't think it's appropriate for that statement to be read at this time.
If the information provided is inconclusive for me to make a judgment, then how do I make that judgment?
I have nothing further to add at this time. That's my recommendation.
I think, Mr. Imhoff, just because I know this is a sensitive matter, unfortunately, we are bound by the regulations and sort of the framework of the city at this time. So I guess I will follow our attorney's recommendation. I think, however, obviously, I think that whatever you have to add to this conversation is going to matter, and most likely it will come up in some fashion during our deliberation. But I do tend to agree, let's not go ahead and make any statements, but I imagine you have very strong views on this subject, and we will discuss it.
Would that discussion be prior to making our decision on his
Absolutely.
appeal?
Yes, it's going to be during, when we bring this back to the Planning Commission and have a deliberation between all of us.
That'll be fine.
Thank you for that.
To clarify, though, pre-written statements should not be permitted during the
Right.
deliberations.
Yeah, no, this will be, I envision this as a conversation, and, please, I think we're good. We're all adults.
I can memorize it, okay?
Thank you. All right, and then Doug, you had a question as well?
I can hold mine off till the deliberation.
I did also have a question. So my understanding, especially pertaining to, I believe, 3 and 4, and maybe even item 5 or question 5. So we were very specific in asking about sort of the intent of city council, and I understand that that is difficult, right, to ascertain. And so here, everything is saying that this is not relevant, the provisions are clear. So that makes sense to me, but I'm kind of curious whether the language, like whether there's a potential for this ordinance to be amended through city council in the future to sort of take the issues we've raised under consideration.
Mr. Hitchcock, I can take this. So yes, of course, that is city council's role, and it's their power to do so. So they can choose to amend the ordinance as they see fit. As I'm sure you're all aware, the last city council meeting, the VHR ordinance was raised. There are changes that are being considered. However, the law of the land today is the ordinance that we have in place.
Appreciate that. Yeah, go for it.
So I'm not sure if I am correct in this, but it is my understanding that the Planning Commission can make recommendations on procedures and possible changes to planning and ordinances and things like that. Is that correct?
Yes, I believe the commission has an opportunity to make a report to city council. Mr. Hitchcock, you might be able to fill in some color on that.
Yes.
But yes, I believe you do have an opportunity to do that.
Yeah, at every beginning of every city council meeting, there is a report out from commissions, and commissioners may appear before city council and report out your actions or recommendations.
Would we need to put something like that on our Planning Commission agenda for us to discuss stuff like that?
Yes, I'd suggest during the commissioner report section, if you can get a second for that, we could put an item on for the commission to consider what recommendations they'd like to make to council.
Okay, and then also, when John was reading that stuff off, I was kind of confused on what he was saying. It was kind of gargled a little bit to my hearing. Maybe my hearing's going out, but was he saying that that the denial, once it's been denied, that they can't get the permit ever again? What happens if the property changes ownership in some sort?
The VHR ordinance limits this prohibition on holding a permit to if an owner and a property, those two have to be in play, the same owner, same property, for the permanent ban to take place. So if the property were to change hands, that property could be eligible again for a permit. Same with if the owner purchased a different property. The current reading would be that that person could then apply for a permit with the new property. But if you have, the owner and the same property, those two things are required in order to have the permanent ban.
Appreciate the clarification. I know we're asking quite a few questions. Do we have anything else before we bring this back for deliberation? No? Everyone feeling good? All right. Thank you. And with that, we will go ahead and now we're going to do public comment, correct? Yes. So we will open this up for public comment for anyone who would like to speak about this specific item. Do we have anyone in the audience who'd like to come up and speak to this? Am I able to talk? I think so.
Yes. You
Yes.
can speak at public comment.
You
yes.
will have a limit of 3 minutes, but but come on up.
Bit of a drive to get 3 minutes. Thank you all once again for giving me the opportunity. I just wanted to I think you all know what we talked about last month, but in the interim time, I printed off and got a copy of the ordinance and reviewed it. And one thing I do not see in the ordinance is anything stating there's a permanent ban if after 3 citations in a 2-year period happen. I do read that in a 2-year period, if I'm still within 2 years, which I am until this coming January, then after that, I would be, the way I read it, eligible to get a permit. That's one. The second thing is, based upon how this happened, I personally view this as a single incident, not 3 citations. There were 3 citations issued, but they were done so within 10 days. And they were also done when I was under the impression from Sonia Wheeler's predecessor, Maureen Stolman, that I would have a decision by December the 14th, which did not happen. It didn't happen until over a month later on January 16th, which is why I put it back up on Airbnb, because I thought that it was okay. That wasn't true. Once I got those citations, and those 3 citations in that 10-day period, I have taken it off Airbnb, and it's still off Airbnb. And again, this is a single incident of me advertising the property under miscommunication, and all of my transient occupancy taxes were paid. I never had complaints from any neighbors. I never had trash problems. I never had parking problems. I never had any other problems renting our facility. I'm a 5-star host on Airbnb, and I appeal to all of you that you accept my appeal, and if you don't, then I certainly would like you to bring this to the city council so that a permanent ban for something as punitive as this is not in play, because I would like to eventually rent our property again, hopefully now, but thank you.
Sir, do we have anyone else in the audience who'd like to speak on this item? Seeing none, we'll go ahead and open it up to our virtual platform.
We'll open it up to our Zoom platform for anyone who would like to provide public comment on agenda item number 2. And there are no hands raised, Chair.
Thank you. With that, we'll close public comment and bring this back for deliberation to the Planning Commission. And we'll just kind of, I think it worked pretty well last time, so we'll go ahead and start with Mr. Williams.
So I'm kind of confused. Is it the date that the first violation is, the date starts from the first violation? Is that correct? From the date of the violation?
Are you saying to have a qualifying event?
Yeah.
I believe so. It would be the date that the citation was issued for.
Okay, so his first one that made the 3 was sometime in September. So, you know, it would have already been over with if, unfortunately, he would have applied after that. But that's neither here nor there. He should have probably waited on applying on that. Now, is he correct? He just stated that there isn't anything in the ordinance about a permanent ban?
The ordinance provides for a permit to not be eligible for a permit once you have the 3 qualifying citations within the period provided in the ordinance. There is no mechanism in the ordinance to apply for it once it's been, once you do not qualify. So while there's no language specifically saying it's permanent, there's no mechanism for him to reapply once you've lost eligibility. So effectively, it is permanent.
Excuse me, nothing to add. Oh, that seemed really loud. Nothing to add since last meeting. I just would, the way I'm feeling and what I'd like to express is I think it's really, again, just really important that we're consistent with how we treat all of these appeals of the Planning Commission. There could well be a lot of them. The more indecisiveness there is, the more likely it is for people to appeal. And everybody's allowed to appeal, but I really trust city staff. I know they've been doing a great job reading through everything. It's like everything's super well documented. I don't always agree with all the rules, but our job is to like rule on those rules. So my thoughts haven't changed since last time. I mean, like as the facts read, I feel like the city did the right thing, and the appeal should be denied. So that's I don't feel any different this month than last month.
Mr. Imhoff?
I think I've said enough. I'd like to say more, but I appreciate the rules and regulations that we're bound by. So I just wish that these were simpler matters, because this is very complex, and it's going to have to be looked at by the city council, because we are denying people their constitutional rights by this action. Thank you.
I would agree that I'm trying to see this in a more black and white position than I did at the last meeting. The city did go back and do a lot of research, and their findings that Mr. Hitchcock read are very straightforward. And our job is to rule on the current city code, the current ordinance, and whether our opinion differs from that, it doesn't matter. It's what is written. So, but I love Commissioner Williams' idea of doing a planning commission report to present at city council to possibly make some amendments, because I think that would be really important going forward. Now that we're seeing all these little things crop up, when ordinances are created, it's kind of that little buried language that you don't really realize is going to have an effect on people. And we're seeing that firsthand, that it is affecting people in a huge way. So I think it would be important that we do look at that as a group and work on that together and move forward.
One other thing.
Yeah, go for it.
I do believe that the city council needs to review the supremacy clause, that the federal constitutional laws supersede city ordinance, and municipal corporations continue to enact policies that can infringe on constitutional rights. Thank you.
Everyone. I think, we're all kind of the same mind. Obviously, as Gavin mentioned, we need to be consistent. And I think, I really appreciate actually this particular planning commission in that we are taking the time to really talk about this, because it's going to impact, as Julia mentioned, a lot of people in a pretty significant way. I also agree that obviously we cannot, it's not our purview to step out of the rules that are set upon us, right? We're not the decision-making body. We're not lawyers. And so, we are definitely bound by what is written right now, but the fact that we do have the opportunity to provide input and potentially improve the ordinance as written and work with city council, and, all of these potential appellants, and then, potential people who are applying for these permits, to hopefully make the process easier and more fair in the future. I think that's a really big deal. So I think, thanks to staff, we have really, really clear guidance on what we pretty much have to do today, I think based on sort of the regulations we're under. But I think that we also have the opportunity to modify and improve the process going forward. So I think, barring further discussion, we're pretty much ready to make a motion. And Mr. Imhoff, I think maybe you want to make it, or do we want somebody else to make it?
I can make a motion if you like.
I would love it.
I move that Mr. Grove's appeal be granted, and that the citations outlined in the short-term rental permit denial not be used against him in the issuance of a new permit for short-term rental.
I don't know that we're going to be able to second it, but
Fine.
thank you for making the motion. Would anyone else like to make a motion?
I think you first have to call.
Oh, do we have a second? No. All right.
Yes, I'll make a motion sorry, just still getting used to this new computer system. Make a motion to pass a resolution making all findings set forth in the resolution and denying the appeal.
I will second that.
And I'm sorry, the system is not letting me mark down that motion and second, so we are going to take a verbal vote. So Chair Viorchek,
Aye.
Vice Chair Lexinger,
Aye.
Commissioner Feiger,
Aye.
Commissioner Imhoff,
No.
Commissioner Williams. That motion carries.
Thank you, everyone. And, Mr. Grove, thank you so much for being here and for sort of, during your public comment, really understanding where we're coming from. We are looking forward to discussing this further. So thank you. All right, we will go ahead and move on to new business, which is our Tahoe Fly Fishing Outfitters Major Design Review, TRP Commercial Project Review, and request for an allocation and transfer of 712 square feet of CFA. Hello.
Hello, Madam Chair and fellow commissioners. For the record, my name is Catherine Moore, and I'm an assistant planner with the City of South Lake Tahoe. Tahoe Fly Fishing Outfitters, represented by David Goldman Environmental Architecture, is proposing a commercial addition at 2705 Lake Tahoe Boulevard. The Development Services Department received applications for a major design review, TRPA commercial project review, and allocation and transfer of 712 square feet of commercial floor area for the construction of a detached storage building. The project site is within Plan Area Statement 103, also known as Sierra Tract Commercial. The site currently contains an existing building with a general merchandise store use. The project site was developed for Tahoe Fly Fishing Outfitters in 2003, was constructed in 2004, and has been operating under the same business since then. The proposed project will expand the existing general merchandise store use, which is an allowed use by right. As you can see on this map, the subject parcel is directly adjacent to developed properties with commercial or public service uses. The site is located within TRPA Scenic Roadway Unit number 35, which is currently out of attainment. This means that this project is visible from US Highway 50, a TRPA designated scenic corridor, which requires additional analysis to confirm that the view sheds and view corridors are maintained and enhanced. This image shows the existing development when traveling west on US Highway 50, and the arrow demonstrates where the proposed project will be located. This slide shows the existing and proposed site plans. Clouded on the left is the full extent of the project scope. The project scope includes constructing a detached storage building, adding a dumpster enclosure, and replacing a portion of existing gravel parking with paved parking on the site. The proposed placement for the storage building allows it to be partially screened by the existing building, thus only the front and a portion of the side elevation will be visible from the scenic highway corridor. The existing dumpster will also be relocated to not encroach within the required rear setback and will incorporate fencing to screen it from public view. Since the proposed building placement will not affect the street frontage, the applicant is not required to provide additional landscape screening. The site has existing landscape setbacks and infiltration basins at the front and rear of the parcel, which comply with landscape requirements per city and TRPA code. The proposed storage building will supplement the existing commercial use on the site, thus requires commercial floor area or CFA for the construction of the space. The applicant has submitted a request to the city to purchase 712 square feet of CFA, which has been approved by the city manager on July 21st, 2025. The project is eligible for the discounted CFA rate pursuant to City Council Resolution 2023-051, which will generate $5,283.04 in revenue for the city's housing program. The proposed storage building is consistent with the city's building design standards and commercial design guidelines. The overall form is an asymmetrical volume that maintains clean lines and highlights a shed-style roof. To unify the site structures, the project aligns the height, building placement, and exterior materials with the existing building. In addition to the building design elements, the project will also be cohesive through similar exterior materials and colors. The building materials include a standing seam metal roof, vertical metal siding, and stone wainscoting. The proposed colors resemble the existing building color scheme by incorporating various shades of dark brown and dark green. This slide provides three-dimensional views of how the two buildings will look like side by side. Overall, the proposed project successfully blends distinct architectural styles into a cohesive design by utilizing similar materials, colors, and building design elements. City staff supports Planning Commission to pass a resolution finding the proposed project is exempt from CEQA pursuant to Section 15332, Class 32, approving the major design review and TRPA permit, granting the transfer of 712 square feet of CFA to 2705 Lake Tahoe Boulevard, and making all other findings set forth in the resolution. This concludes my presentation. I'm available to answer any planning-related questions that you may have, and the owner and design professional are also here today to answer any project-specific questions. Thank you.
Thank you, Ms. Moore. Do we have any questions regarding this project? No, go for it.
I noticed it has a garage door. Is this going to be used for storage of vehicles and such?
It will be used for storage for the existing use. Perhaps the business owner can come up and speak more about it.
Yeah, so the 800 square feet is going to be used to store utility vehicles that we use for guided fly fishing tours.
That's pretty much it.
Yeah, okay, thanks.
Thank you. Do we have any additional questions? Or any questions about the presentation? Nope. All right, we'll open it up for public comment. Seeing no one in the audience, let's open it up for Zoom.
We'll go ahead and open up our Zoom platform for anyone who would like to provide public comment on agenda item number 3. There are no hands raised, Chair.
Thank you. With that, we'll bring it back to Planning Commission. Do we want to deliberate?
I would say I go by there all the time, so, and went by today and was really, and glanced back there to where this new storage area be, and they already have everything kind of stacked. It seems similar to the auto body shop, where they're already using the space, now they're making it look nicer, so it seems great.
No.
All right. Yeah, no, in general, great project, nice job. Let's make a motion.
I'll make a motion to pass a resolution finding the project is categorically exempt from CEQA pursuant to Section 15332, Class 32 infill developments, and 2, approving the major design review permit and the TRPA permit. 3, granting the transfer of 712 square feet of commercial floor area, CFA, to 2705 Lake Tahoe Boulevard for the construction of a new storage building, and 4, making all other findings set forth in the resolution.
I'll second that.
Commissioners, are you seeing the option to vote now? Okay. Commissioner Imhoff, do you have the option to vote?
I'm not on that one, am I? Fly fishing, I'm sorry. What? Little guy. Well, I've already signed in.
Have you clicked the join the meeting button in the upper right-hand corner?
I was already signed in, but something happened. Add new account, sign in, see. Jesus criminy. I was in.
I'll just take your verbal vote.
That would be great.
Okay, Commissioner Imhoff, how do you vote on this item?
Hey,
Okay, that motion carries.
Thank you. And we are continuing our next item, correct?
Correct.
All right, so on to our item number 5, which is a vacation home rental application denial at 3340 Pioneer Trail. And once again, we will be going through sort of this quasi judicial process on this. So I am first going to explain that we are considering the appeal of Seamus Fitzsimmons regarding the denial of VHR permit application at 3340 Pioneer Trail. Yeah,
Is it Seamus or is it Lawson?
is it?
One of them got continued, I don't think
Item,
Yeah.
item number 4.
Item 4 was continued, which is the Black Rock property. We are looking at 3340 Pioneer Trail.
so we're skipping on the Pioneer Trail.
Oh, what happened to 4?
The attorney wasn't able to be present, so we are continuing to a later date.
Before we get started,
And Chair, if I may, our appellant is present over Zoom, so I will be promoting him as a panelist.
Thank you.
And when it's his turn to speak, he will be speaking over Zoom platform.
Perfect. And Dan?
can we take a short 5-minute break?
Yes, I think I need a refresher. So, John, 5 minutes?
Sure.
Thank you. Everybody, thank you for your patience, and Dan, I'll go ahead and let you make the statement first.
All right, so again, for this item, I want to ask that the commissioners disclose any ex parte communications you've had with any third party regarding the matter that's under appeal here. If you have any, please disclose the substance of the communication and who is party to the communication.
I have none to report.
I haven't had any.
Haven't had any.
I haven't had any.
I have none.
All right, thank you. And Mr. Hitchcock, I'm going to hold you up a little bit. I'm going to go ahead and read back through the procedures so that everybody is quite clear on how this will be organized. So first off, once again, this is where, as the commission, we are considering the appeal of the vacation home rental denial at, I believe it was 3340 Pioneer Trail. And we are confirming that notice of the appeal hearing has been given to the appellant. We've been told that he is available via Zoom. So first, we are going to hear evidence and testimony in the following order. We will receive an opening statement and remarks by the staff, which will provide background on the matter. And there's a suggested time limit, but we are not going to have any time limits on these. We will give everyone plenty of time to speak. Next, we will have an opening statement or any remarks by the appellant and or their attorney, and evidence or testimony from them, followed by any questions by the commission or others, which includes staff who wish to ask questions. Next, we will hear any evidence or testimony from staff concerning any issues raised surrounding the matter, followed by comments by the applicant. If the applicant and appellant are different parties, then followed by any questions by the appellant and commissioners. Then we will have the evidence or testimony from the appellant and or the appellant's attorney in rebuttal to or in clarification of any testimony presented and any closing statement or remarks that the appellant wishes to make. Finally, we will have public comment. And then following the presentation and the testimony, this will come back to the Planning Commission where we will deliberate on the evidence and testimony. And we will vote whether to grant the relief or deny the appeal. And then the secretary will announce the final decision of the commission. So it'll be a little bit of back and forth. We'll try and keep it on track. Let's go ahead and get started and hear from staff. So Mr. Hitchcock.
Good afternoon, Chair and members of the commission. For the record, John Hitchcock, Planning Manager. The item before you is appeal vacation home rental permit denial. The appellant, the property is 3340 Pioneer Trail. The appellant is Mr. Seamus Fitzsimmons. His application was submitted on June 23rd, 2025. That was the first day that applications could be submitted for preferred applicants. His application was deemed complete August 12th, 2025. That means that all required documentation was submitted on that date. And then his application was rejected due to a 150-foot buffer conflict on August 13th, 2025. That concludes my introductory remarks, and I will provide evidence when I come back up again. Thank you.
Thank you so much. So in that case, we'll go ahead and hear an opening statement or remarks by the appellant and or their attorney. So we'll go ahead and open up to Zoom.
Yes, my name is Seamus Fitzsimmons. Good afternoon, commissioners. In the interest of saving time, I submitted my comments, which I was told you would have before you. So I'll just offer a more condensed summary of those comments, if you would like. I'm here as a prior VHR permit holder in good standing, applying within the designated priority window, as Mr. Hitchcock acknowledges, under Resolution 2025-052. My permit was not revoked due to any violation, expired solely because of Measure T, which of course you know the court has since struck down. The city denied my priority VHI permit application based on the 150-foot buffer rule, as Mr. Hitchcock points out. It's a rule which, as you know, I believe the city has now rescinded. However, this appeal is not moot. It remains unresolved as my priority placement for a permit remains unaddressed. I respectfully argue that the denial was a retroactive application of a new restriction that contradicts both the ordinance and the resolution. Resolution 2025-052 clearly states, quote, "Nothing in this resolution shall be construed to apply retroactively to disqualify any preferred applicant whose prior permit was validly issued and maintained in good standing prior to the implementation of Measure T." The buffer provisions adopted in Ordinance 2025-1200 shall not operate to exclude such applicants solely on the basis of proximity to other permitted parcels. Commissioners, this language is unambiguous. The buffer rule should never have disqualified me, and now it no longer applies. My neighbor's permit was issued during the same application window, primarily because their inspection occurred first. That sequencing forced us into competition for proximity despite equal standing, with neither was subject to the buffer rule. This process lacked a transparency and fairness in prioritizing logistics over merit, I believe. And I meet all the criteria for preferred applicant status: no citations, no unpaid taxes, no lapses, no transfers. Denying my application undermines restorative intent of the ordinance and erodes public trust in the fairness of the permitting process. I respectfully request that the commission overturn this denial and issue my VHR permit pending inspection, or alternatively restore my priority as a preferred applicant and proceed to VHR permitting. Additionally, I ask that the commission recommend a refund of my appeal fee. This appeal was filed in good faith, is not frivolous, and under the rule that has now been repealed and was never intended to apply retroactively. A refund would reflect the city's commitment to fairness and procedural integrity. I thank you for your time and consideration.
Thank you, Mr. Fitzsimmons. So we do have the opportunity at this time to ask questions of the appellant from either the commissioners or staff. Do we have any questions for Mr. Fitzsimmons at this time? Nope. Oh, yes, go ahead.
So I'm correct in assuming that the only reason why your permit was denied was because of the buffer. Is that correct?
Yes, in the communications that you should have in my packet that I submitted to the commission, the only reason was the eligibility was based on the fact of the 150-foot buffer rule, as Mr. Hitchcock has explained.
Thank you. No further questions.
Thank you, sir. Guessing we don't have any other questions, so we'll go ahead and bring Mr. Hitchcock back up. Let's have some more information.
Thank you, Chair. Again, John Hitchcock, Planning Manager, for the record. So I'll just go through the chronology and the evidence that we have on this particular appeal. Mr. Fitzsimmons' application was submitted on June 23rd, 2025. As I mentioned earlier, that was actually the first date. His application was time-stamped, let's see here, was time-stamped at 9/49, and he was number 213 on the list. So per the code, Mr. Fitzsimmons, as I mentioned, is a preferred applicant. He had a previous permit, was in good standing, and did not have any outstanding fines or any upheld citations. Thus, Mr. Fitzsimmons was able to submit an application in that first round of applicants as a preferred applicant. As I mentioned, it was submitted June 23rd, 2025, was timestamped at 9:49 a.m., number 213 in line. The application was deemed incomplete due to missing ownership information. Mr. Fitzsimmons finally submitted a grant deed to the Community Services Division on August 6, 2025, and the application was deemed complete on August 12th, 2025. On August 13th, Mr. Fitzsimmons was informed that the property conflicted with another property, 3326 Pioneer Trail, conflicted with that buffer because an issue was issued to that particular property on August 13th. 3326 Pioneer's application was also submitted on June 23rd, 2025, and was received timestamped 9:04 a.m. and was number 4 on our list. Their application was deemed complete on July 8th, 2025, so before Mr. Fitzsimmons' application. They then went through the inspection process, passed inspection on October 12th, and was issued a permit on August 13th. Because of the chronology and the timing of their application, Mr. Fitzsimmons' application was then deemed in conflict with the 150-foot buffer, and his application was denied. Staff contends that proper procedures were followed and each application was treated equally and in sequence they were received according to the vacation home rental application procedures. Section 3.50.390.A.2 specifically states that it shall be the applicant's responsibility to provide all information and materials required to comply with the vacation home rental application submittal requirements. The code also further states that the filing date of an application is the date the city officially receives the last submission of information or material to be deemed complete. That was the grant deed, which was submitted, let's see here, August, what did I say? August 6th. Thus, the city contends that the permit denial was done properly and in accordance with adopted standards of the vacation home rental permitting process. As Mr. Fitzsimmons mentioned, he did submit comments for your consideration. He had a number of statements, and I would just like to respond to some of to his letter statements. The one, as it relates to preferred applicant status, city does not disagree with Mr. Fitzsimmons. His application was taken in because he was a preferred applicant. His statement regarding retroactive application of buffer rules, Mr. Fitzsimmons is correct. The buffer rule was not in effect when the original permit was issued and was never part of the original framework during implementation of Measure T. However, that framework has ceased to exist once the court found Measure T to be unconstitutional. Mr. Fitzsimmons' application is being considered under a new framework, which includes a buffer, and thus the property is subject to the buffer rule. The previous permit and previous framework are irrelevant to this appeal. Mr. Fitzsimmons did directly quote a paragraph from Resolution 2025-052 to support the claim that the buffer rule cannot be used to disqualify the property. Staff has reviewed the resolution and cannot find any reference to this paragraph. I've also provided the commissioners a copy of the resolution for your review, which is 2025-052. There's no mention of the specific language that Mr. Fitzsimmons references and which he read out.
Great.
Number 3, Measure T declared unconstitutional. The city agrees with the statement and that the new ordinance was adopted to allow short-term rentals outside tourist core that included a buffer. That replaced the old ordinance. However, there was no explicit promise made by the council that every previous permit holder would receive a permit, but rather previous permit holders in good standing would have priority in the application review process. 4, timing, ambiguity, and procedural fairness. As I mentioned further, staff contends that the application was properly processed in accordance with the vacation home rental ordinance. Conflict with public policy goals. City staff agrees that the buffer was designed to prevent clustering and preserve neighborhood character. However, when the council was debating this issue, they were well aware and acknowledged that the buffer may potentially exclude previous permit owners from obtaining permits. And that concludes my presentation. Thank you.
So much. And at this time, the appellant and the commission may ask questions of staff. So we'll go ahead and see if the appellant, Mr. Fitzsimmons, has any questions at this time.
Oh, sorry, actually, there's one other step here. So the applicant can make comments, and then we'll open a question period for the applicant to ask questions of the commissioners and of staff.
Okay, so first, if Mr. Fitzsimmons wants to make a statement, he may.
Yes, commissioners, the quotation I gathered was basically I just got off the internet. So I was under the impression under several investigation that that actually does exist in the ordinance. If I'm mistaken about that, I apologize. I offered it in good faith. However, I do like to point out that my understanding is that the buffer rules could be rescinded altogether. And I still think that my priority application should take a certain precedence. With that understanding that the city council has recognized how unfair the buffer rule has become. So that's what I'd like. I think that's all I need to add at this point.
Appreciate that. Thank you so much. So now we will go ahead and have questions from both the appellant and the commissioners directed to staff, if there are any. Do we have any questions? Go for it.
I guess one, now that the buffer rule has changed, can the appellant can he reapply in the open, or is it already like oversubscribed? Like, can he reapply like right now in the open call?
So the direction from city council at the last meeting was to come back with amended ordinance that removes the buffer. However, that has not taken place yet, so the law of land is still the 150-foot buffer. This particular property has no citations, no fines, and so under a new framework, they would be able to apply pending amendment of the new ordinance, which may or may not include a cap.
If come October or December the 3rd, I think is when the earliest possible, with it, any new ordinance would be, if they are able to get rid of the buffer zone, and that's still up in the air because you still have a first and second reading. Would the applicant be a priority and go in front of all the other ones?
Well, that would be at the discretion of the city council, if they choose to create a preferred applicant pool after removal of the 150-foot buffer.
So right now, we don't have a proposed ordinance that's drafted and been submitted to council, so we don't know yet at this point if there will be any preference for anyone.
Can we make a suggestion that they do a priority for the ones that have been denied due to being buffered out?
That's up to the commission. If you want to include that in a report to city council, through the framework we discussed earlier, you're welcome to do so.
Kind of a follow-up question. So we touched upon this. How are we doing on the VHR permits that have been issued? Not the ones that are in processing, but how many do we have, I guess, effectively left?
I don't have the stats on me, but I know we've issued a few hundred.
What's our max at this point? Is it 900?
There's no
There is no
cap.
max.
There's no cap. The 150-foot buffer was basically created an artificial cap.
Gotcha. So to just clarify, in theory, if the buffer is eliminated, this property would be able to apply for a permit because there is no maximum of available VHR permits
Well,
within
they
the
would be
city
able-
at this time.
Yeah, they would be able to apply because they have no citations, so they wouldn't be banned from applying. Now, the city council may adopt a cap like previously, prior to Measure T. We don't have that language yet in what's being proposed, other than a direction from council to remove the 150-foot buffer.
Thank you. I don't have any other questions. Do we have anything else? No. Thank you very much. So with that, we will, turn myself off. So now we will go ahead and hear any evidence or testimony from the appellant or their attorney in rebuttal to or in clarification of the other evidence or testimony which has been presented, and any closing statements or remarks that Mr. Fitzsimmons would like to make.
Chair, actually.
Yeah?
We missed one component. So the appellant now has an opportunity to ask any questions. I don't know if we
Oh, we did
Did
that
we-
at the beginning, and
did that at the beginning. Okay. Well, he had a chance to do his comment. You might want to just ask him again if he has any questions for
Sure.
staff.
got it. Mr. Fitzsimmons, did you have any questions for staff?
Yes, just in researching on right now and like that, it keeps coming up and saying that I'm not mistaken and that it was adopted in June 25. I believe of this year. So I still have questions of whether if I'm mistaken or not. I understand Mr. Hitchcock has reviewed that and hasn't seen it, so I would like to research it further, quite honestly, and get clarification and to ascertain that I am actually mistaken.
Mr. Fitzsimmons, may I respond? Sure.
Please.
Mr. Fitzsimmons, are you referencing Resolution 2025-052?
Yes.
Okay. Yeah, that, a copy of that is included on page 229 of the Planning Commission agenda packet, if you have access to that document.
I'm sorry, I didn't see that.
Yeah,
I wasn't given any staff comment.
Yeah, adopted June 17, 2025. This is the resolution that established the preferred applicants.
Okay.
I can speak to this as well. So the staff has reviewed the comments submitted by the appellant, and the language that he's quoted is not consistent with any existing regulations regarding VHRs in South Lake Tahoe. So it's not accurate.
Thank you. I apologize, but again, I was just taking the information I got from the internet. So that was my bad.
Mr. Fitzsimmons, do you have any other questions besides this one?
No, I think I understand that you have to follow. I don't think that is the process that the council has set out. People have objected to the process. The council has responded. I would hope that somehow I can get the permit at some time, and that somehow that my priority be recognized so I don't lose it in case there is a cap on permits. But Mr. Hitchcock has pointed out there's not a cap, so I don't think I'm in danger of losing the permit per se.
You, Mr. Fitzsimmons, and so I know we kind of muddled through. So technically, the next step does allow you to make further testimony or comment or closing statements. Do you want to add anything else to your last statement?
No, I think not. Thank you.
Thank you very much for your participation. And with that, we will go ahead and bring this back to public comment. And seeing no one in our audience, let's open it up to Zoom.
We'll go ahead and open up our Zoom platform for anyone who would like to provide public comment on agenda item number 5. There are no hands raised, Chair.
Thank you. In that case, we will now deliberate on the evidence and testimony presented, and we'll vote on how we would like to proceed. So we will go ahead and bring it back to the commission, and let's start on the left. Mr. Williams.
I mean, it's pretty cut and dry what the city's intention on this was at the time in June when they passed the new ordinance. Hopefully, the city, as I'm sure many of us already know, has instructed the staff to come out with a new ordinance with the 2 different categories. Both of them getting rid of the buffering zone and adding a cap of, I believe, 1,200. Hopefully the city, it's supposed to be coming up in the first meeting in October, I believe. And hopefully they'll be able to move this forward on a first reading, that they still have the votes for that. But I think this is pretty cut and dry of what the city's intention was that they did, though they found that they are relooking at it because it brought a lot of issues up. It would be best if the city would make a priority of the people who were denied on this because it sounds like they are all pretty much ready to go now, except for the buffering issue. But that's my only comments.
Yeah, I just kind of feel in this unfortunate position that, the city council drafted this ordinance and it's not perfect, and maybe things seldom are the first time, and or at least I feel like we're, as the planning commission is kind of uncovering some of the problems. But we can't change the rules, so I'm kind of, I had 2 thoughts. One is if there's any way, And one is just like the rules are rules, or we could try to continue this, if it is possible, like to continue the appeal until after the city makes a decision about the buffer, because then that would sort of like de facto make it so they don't lose their spot, maybe.
The only reason provided by the protocols to continue would be if additional information is sought, and waiting on further city council action would not be within that.
Okay.
So the law of the land is what it is, so that's where it stands today.
All right, thank you.
I would agree. It's just an unfortunate situation of timing on the application and when everything was complete. I would also agree that I would like to see Mr. Fitzsimmons get priority processing or some kind of preferred status if the buffer zone does in fact get written out of the ordinance. Hopefully, we'll see in October or going forward. So that would be my hopes for him.
Ditto, 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 and ditto. I agree with everybody. Thank you.
Thank you. So I have one quick question. So since Mr. Fitzsimmons' application was denied, is it still in the system? Like, let's say city council does proceed, the buffer is removed, all is good, he reapplies. Does he have to like literally reapply, or is it more like you're already here, we're continuing?
My understanding of the process is he would have to file a brand-new application.
Oh, geez.
But, you know, I would highly recommend that Mr. Fitzsimmons, because, you know, he's gone through this appeal process and he's been denied, that he definitely participate and provide public comment during the adoption of the vacation home rental ordinance so that the city council members can see kind of some of the unintended consequences. And maybe through that public testimony process, the council may be open to creating a class of people, creating a preferred applicant from that class of people that were denied permits because they were buffered out. This is not the first one.
Were his application fees refunded?
Application fees are not refundable.
Okay, so,
I thought the city council instructed the staff to refund denied ones on cases.
I can look in that. I vaguely remember they made some mention of that, but I can look into it. And I can also check in with the not development services, but community service division on that application and whether they can reuse existing application or new application once the new ordinance, the amendments are adopted by the city council.
So the application fee would be outside the scope of what's before the commission today. That's something that could be considered at the staff level, but the denial of the permit is the only decision that is before planning commission today.
appreciate that. I don't think I have any other questions, and in general, I mean, I think we're all on the same page, and we're all very curious to see what will come of sort of the amendments that city council is looking at. I'm hoping that Mr. Fitzsimmons and many others participate in the process and continue, you know, to make these public comments and sort of improving it as we go on, because, you know, as we all kind of see, we are really kind of finding some real problems here. So I appreciate it, and I think we are probably ready to make a motion. Does anybody want to do it? All right, go for it.
All right, I'll make the motion to pass a resolution making all findings set forth in the resolution and denying the appeal.
Second.
That motion carries.
All right, thank you, everyone. That was, once again, quite interesting. And so now we will go ahead and hear some updates and announcements from city staff.
The only announcement, your next planning commission meeting is October 16th.
Nothing to report.
All right, well, that covered it. In that case, planning commissioner reports and comments, and I believe this is where we discussed the possibility of making a decision about whether to add an item to the agenda to discuss a presentation before city council regarding several of the issues we sort of recognized today. So how, do we need to make that super official?
So
How do we do that?
to put that on the agenda, you would need someone to propose an item, and you'd need a second for that item. And then it'll be heard on the agenda for the next meeting.
Does it have to be specific, or can we, when we bring it on the agenda for our next meeting, can we discuss this thing and then approve it at that time?
Yeah, I would say it can be somewhat general. You could just, something along the lines of discussion regarding recommendations to city council related to VHR ordinance amendments. And I think that would do it.
Can I recommend, are we able to add a new standing agenda item to our agenda? So let me back up. City council, we all listen pretty often. They have this commissioner reports. Anybody from a commission can stand up and give a report, but I feel like that should be supported by all the commissioners if that's the case. So I'm wondering if we could have a standing item, and maybe we don't always use it, but for us as a group to develop that report to city council for the next city council meeting. I don't think it would take us much time. We wouldn't have to always use it, but at least we'd kind of have a standing venue for stuff like this.
I would suggest let staff look into that. For the next meeting, you'll have it for this issue, and then obviously if you want to add anything else to it for the report, you can do it at that time too, and then we'll get back with further recommendations on it, a standing item.
Okay, I'd like to request that we have at our next meeting a discussion on possible recommendations to city council meeting about VHRs. Something we'd be able to put on the next meeting?
Yes.
General, I like your idea of making it a standing item, because that way we don't miss an entire month in case something else comes up. I think that's it.
Is this something that we would discuss?
Oh, do you want to add your?
Sorry.
Yeah.
Is this something that we would discuss as a group prior to this, or will we have a special meeting? Will we have a special group meeting at our next one before their meeting? Is
Yeah,
that
so
what you're
it would
saying?
be a discussion that would take place at the next planning commission meeting on the record
Okay.
to decide what to report to council.
When is the city council meeting about this? When's the first city council meeting in October?
Bear with me for a moment.
It is on October 21st, and it is at 5:30 p.m.
Okay, so we would be before then.
Yes.
Sure, I had a question actually for Mr. Bardzell. As the vacation home rental is an ordinance, so that would have to come to planning commission, the amendments itself, wouldn't it?
I don't believe so. I'm not aware that it's planned to come to planning commission. My understanding is it's going to council for the next, for the meeting.
The one in June didn't come.
Correct. I don't think it did. So I would expect that it does not need to come to planning commission.
Just to kind of clarify, so our meeting's October 16th. In theory, we'll be able to discuss this as an agenda item. And then potentially we could at that, make it for the October 21st meeting with city council with our commissioner reports, correct?
With the one caveat that I'm not sure about the date that the ordinance is expected to be heard. I'm hearing October just during this meeting, but I don't have that information. So assuming it's heard after the next planning commission meeting in October, then yes, you'll be prepared.
We could make a report regardless of whether they read the revisions to the ordinance, right? We could still make a report and give them sort of our feedback.
Of course.
Okay, perfect. All right, do we have anything else? All right, let's go home. We're adjourned.